Welcome to Immigration Quicktake. This is Ellie Rutledge-Silver with the American Immigration Lawyers Association. Last week, AILA and the American Immigration Council, as part of the Dilley Pro Bono Project, filed suit to challenge a new ICE policy that interferes with the ability of the project staff to represent their clients effectively. Here to share more is Melissa Crow, Legal Director for the American Immigration Council. Melissa, thanks for joining me. Why is the suit being filed?
Ellie, the impetus for filing this suit is that one of our legal assistants with the Dilley Pro Bono Project has been deprived of access to the Family Residential Center in Dilley, Texas. The reason is, at least ostensibly, that she violated ICE's policy of requiring pre-approval before conducting a telephonic mental health consultation with one of our clients. So in addition to challenging the denial of her access rights, we're also challenging this policy, which we believe violates the First Amendment rights of our lawyers and our legal volunteers, as well as the Administrative Procedure Act.
What impact did ICE's decision have on the project's ability to represent clients?
I think it's important to realize that the point in the case where we usually do a telephonic mental health consultation is really at the 11th hour. We simply don't have the resources to do them for everyone who's in detention, and so we generally wait until after the initial credible fear interview. If someone receives a negative determination, they then go before an immigration judge to seek review. And if the negative determination is affirmed, then they might submit a request for reconsideration to the USCIS Asylum Office. And it's in support of that motion for reconsideration that we do what we can in appropriate cases to enlist the assistance of a mental health professional who's willing to do the consultation free of charge. Obviously, we have to work around the schedules of the individuals who've agreed to do these consultations, and we don't always have a lot of flexibility in that regard. ICE insists on having at least 72 hours to respond to a request for pre-approval, and it's very possible that somebody could be deported before those 72 hours have run. So essentially, our lawyers are faced with an untenable choice between what's in their client's best interest, which may very well be a mental health consultation to explain why their story may not always be consistent or coherent, and losing their access to the Family Residential Center at Dilley for allegedly violating this purported ICE policy requiring pre-approval.
What happens now?
So the complaint was filed late last Thursday night, and the papers were served on the defendants early this week. The government now has 7 days to respond to our application for a preliminary injunction. And under the local rules of the DC District Court, either the court has to set a hearing on the application for preliminary injunction or decide it within 21 days of service of the documents on the government. So we have about 3 weeks until we know what's going to happen in terms of the application for a preliminary injunction. So stay tuned.
Thanks, Melissa, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.